Understand your employment rights when taking maternity or medical leave. This guide breaks down the federal and state laws designed to secure your job, income, and dignity during these crucial times. Let's start with a foundational principle. You have the right to take protected leave, and in many cases, your employer cannot fire, demote, or penalize you for using it. Understanding the laws that protect you. There are several key laws that govern leave rights in the U.S., each designed to cover different circumstances. At the federal level, we have the Family and Medical Leave Act, FMLA. This law provides up to 12 weeks of unpaid, job-protected leave per year for the birth and care of a newborn, placement of a child for adoption or foster care, a serious health condition that prevents you from working, caring for a spouse, child, or parent with a serious health condition. To be eligible, you must work for an employer with 50 or more employees, have worked there for at least 12 months, have worked at least 1,250 hours in the past 12 months. Some states, like California, go even further with their own laws, such as the California Family Rights Act, CFRA, and Pregnancy Disability Leave, PDL. These laws may offer longer leave periods, broader definitions of family, and coverage for smaller employers. Maternity and pregnancy leave, what you're entitled to. If you're pregnant, you may be entitled to pregnancy disability leave in addition to family leave. In California, for example, PDL allows up to 4 months of job-protected leave if you are disabled by pregnancy, childbirth, or a related medical condition. This leave can be taken before or after birth, depending on your medical needs. Once PDL ends, you may also qualify for CFRA leave to bond with your baby, giving you potentially up to 7 months of protected leave when combining both. Many employees are unaware of this layered protection. Understanding how these laws intersect is key to planning your time away from work. Medical leave for your own health. Whether it's a surgery, serious illness, or mental health condition, medical leave is your right under the law, if your condition meets the legal criteria of serious health condition. This generally includes inpatient care, chronic conditions requiring ongoing treatment, conditions causing extended incapacity from work. During your leave, your employer must maintain your group health benefits under the same terms as if you were working. And once your leave ends, you are entitled to return to your same job or a substantially equivalent one. What employers can and can't do. It's important to know what's not allowed under the law. Your employer cannot deny you leave if you're eligible, pressure you to work while on leave, retaliate against you for requesting or using leave, demote, discipline, or fire you for taking legally protected time off. If you experience any of these actions, you may have a claim for retaliation or wrongful termination. At Employee Law Group, we've helped many individuals who faced pressure, harassment, or job loss simply for asserting their rights to leave. Tips to protect yourself. Here are 5 proactive steps you can take. 1. Submit a written request. Always request leave in writing and specify the type of leave you're requesting. FMLA, CFRA, PDL, etc. Include the expected start and return dates. 2. Provide medical certification. If requested, submit a doctor's note confirming your condition qualifies. Don't share more medical information than necessary, just what's legally required. 3. Keep copies of all communication. Document everything. Save emails, request forms, and notes from HR or management. If issues arise, these records become important evidence. 4. Understand the timeline. Know how much leave you're entitled to, whether it runs concurrently, under multiple laws, and when your job protection expires. 5. Speak with an employment attorney if problems arise. If your request is denied, if you feel pressured to return early, or if you're treated differently because you used leave, don't wait. Seek legal advice immediately. Taking time away from work for pregnancy, illness, or family care isn't a privilege. It's a protected right. Understanding the legal framework, documenting your requests, and standing up for your rights can make all the difference in safeguarding your job and your peace of mind. Thank you for watching. If you're planning to take maternity or medical leave, or if you faced retaliation for doing so, contact the Employee Law Group for a confidential consultation. We're here to make sure you're treated fairly, your rights are respected, and your future remains secure.